Good morning, Mr. Chapman.
Good morning, Your Honor.
You can go ahead when you're ready.
Mr. Bouchard is here today after failing to appear before this court on November 2nd, 2022. Bond is currently set at $6,871. This is the fifth bench warrant. It reports that he is employed at Dixon Lawn Care, but is currently laid off. Last payment made on this account was in August of 2023. The court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on February 28th, 2024 at 8:45 a.m. before this court.
Mr. Bouchard, you're before the court charged with civil contempt of court duty or failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on February 28th, 2024 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Right now I got charges I'm fighting now. I'm not gonna be able to probably do really anything.
Okay.
I was gonna talk to you guys about maybe getting like a bond, maybe like I know I can't set my own thing, but I'm trying to like work out bonding myself out for these other charges. I got two other charges I'm dealing with. I get a rating from one today. My mom's got $800 to bond me out, but I was gonna see if I could talk to you guys, maybe doing like 1,000, maybe 10%, like 100 or something, or 200 to maybe get out. Cause I got like 200 cash myself. You know what I mean?
Yeah.
I've been running from parts.
I'll tell you, with the fact that you haven't made payments in a period of time, and your arrearage is obviously large. In this case, it's your fifth bench warrant as well. I'm going to reduce your bond in hopes that you could be released, but I'm going to set your bond in the amount of $1,000. If you're able to post that, you'd be able to be released. Do you have any questions?
Is that 10% or is that 1,000?
No, it's $1,000. It's not 10%.
All right, yeah, so I'm sitting.
Okay. Thank you. You're free to go. Have a good day, sir.
Nobody here for defendants.
Okay. Good morning, Ms. Sharp.
Good morning. Good morning.
It's my understanding, we're going to do the pro confesso hearing today. I've been informed that your client, in fact, had filed for bankruptcy. Is that correct?
Yeah.
Oh.
Yeah. And I'm trying to figure out what's going on exactly, because often that puts a stay on the divorce. And so I'm trying to see if we can, speed up that process and see what's going on, so that we can get this entered.
Just so you know, I mean, I can take the proofs in the matter. I can actually grant the divorce. I can't enter in orders as it relates to assets or anything of that nature. That
Okay.
would have to be a reserve, but I mean, we can complete the case and we can do the divorce, though.
Okay.
So,
Okay.
Why don't you work on that and then get back to us on what you want to do, and I don't know. And then we will, we can simply reschedule the pro con, et cetera.
Okay. That sounds good. My client just did send me a message saying he's signing in. Does the court want to do the pro con right now, or would you rather?
If he's coming in, we'll do it. We'll take the proofs and put it on the record, and
Okay, sounds
and
good.
then you can work out everything else you want to work out. But like I say, if you want a short form, you could do the judgment just granting the divorce and then reserving everything else.
Okay, I will do that. Thank you.
So are we going to wait for that person then?
Yeah, if he's coming in, we'll
Okay.
do it.
I have the ringer ready, so should we pause for a moment and then come back?
8:57 a.m.
Yeah, court will note the appearance of Ms. Jansen Miller on behalf of the defendant. This matter is before the court on the defendant's motion to exclude child in this matter. Just Ms. Jansen Miller, just so you're aware, we don't take testimony on Monday mornings because we usually have voluminous motions and we would never get through anything if that's the case. Court does note that what the court will do is schedule this matter for a Wednesday hearing. We do them Wednesdays at 1:30 p.m. But based upon what you've stated, based upon the time frame that does appear maybe a DNA test would be necessary. Jansen
Your
Miller,
Honor.
what's your response?
Sorry, Your Honor. I had both parties attend today. I know each court kind of does things a little bit different. We had done a stipulated order in a different case, and I didn't know if Your Honor would do that, but all parties are in agreement that this is not my client's child. And Dad was here, real biological dad was here to be able to inform the court that yes, he is. But I didn't know if this court would accept a stipulated order by all the parties or if you would require DNA.
No, I don't. Based upon the time of separation, there is a possibility, so the court would require DNA testing.
Okay.
And again, and I don't do it by stip either. We require that the parties be present and testify so that we have them under oath.
Okay. Would you want to have the testimony before the DNA or
No.
the DNA?
I want the DNA first, and then from there we will go through, and then once we have that, then we can do the hearing.
Okay. All right. So would Your Honor like me to just notify the court once we have that DNA to get it set?
Yep. Once you have the DNA test report back, then contact the court and we'll schedule it for a hearing and have everybody present at that time. Want to thank everyone for being present today. Unfortunately, we just can't do it because we have other motions, and it won't take much. It takes about 15 to 20 minutes max, but we don't have that much time when we have other motions going.
Okay. All right. We will notify the court when we have that information and then get this scheduled that way.
Okay, I want to thank everybody for being present. We'll end this matter at 9:00 a.m. You're free to go. We'll note the appearance of Ms. Capture on behalf of plaintiff and Mr. Vanderhorst on behalf of the defendant. This matter is before the court on the plaintiff's motion to establish temporary custody, parenting time, and support. Ms. Capture.
Thank you, Your Honor. I would like to go first through our motion. Plaintiff is requesting 50-50 parenting time. Plaintiff has adequate housing, a crib, all the necessary things for a minor child to be residing with him. Has only been away from the minor child for about a month and a half, maybe 2 months, given that defendant unilaterally moved out of the home and has since prevented him from having near constant contact with the minor child. The minor child is just 1 year old. He is bottle fed with formula, but that's he's weaning off of that currently. He's not breastfed. Some of the matters spoken in defendant's answer are a little concerning. First and foremost, that defendant is requesting that plaintiff attend parenting classes. There is nothing in plaintiff's history that requires him to attend any kind of parenting class. He's had absolutely no interaction with CPS, no domestic violence, no criminal history whatsoever. Both parents are rather young. Defendant and plaintiff had agreed in their relationship that plaintiff would be the primary financial provider, while defendant would be the primary caretaker. This is a very common arrangement with most relationships where one party decides to stop working, take on the primary caretaking role of the child, and the other party is the primary financial provider. That does not mean, however, that plaintiff just absolutely neglected any childcare. In fact, he frequently woke up in the middle of the night with the child. He actively fed and bathed and changed the child while the child lived with them. The allegations regarding the shooting in the hand are completely misrepresented to the court. The incident that occurred during a CPL training where the party was at a gun range and there was a misfire of a weapon. This had nothing to do with any kind of gun on the premises. In fact, plaintiff does have his CPL license and is able to have guns. I mean, it's his Second Amendment right. Again, Your Honor, the allegations contained in defendant's answer are largely just made up, created issues that simply are not there. Defendant states that she would seek employment if not for the need for childcare. However, plaintiff has on numerous occasions told defendant to bring the child over to him so that he can provide childcare while she's at work. Plaintiff's family is also willing to provide free childcare, and defendant still refuses to gain gainful employment. Your Honor, there is nothing contained in this answer that would prevent plaintiff from having equal parenting time with his child. It's in the best interest of children to have equal parenting time with both parents. And so, Your Honor, we are continuing to ask for a 50-50 parenting time schedule with child support, obviously, to be calculated pursuant to the Michigan Child Support Formula. Thank you.
Thank you. Mr. Vanderhorst?
Thank you, Your Honor. Well, that's just not the case. The plaintiff or the defendant mother has had this child basically 24/7 since birth. Yes, they did live together for the first 9 months of this child's life. They split up in December. My client lives in a nice home with his stepmother and his father, and a beautiful home on acreage in Galesburg area. She does live in Kalamazoo County, Your Honor, and she plans to remain there. But when they were together this child's only 1 year old, just barely turned 1 year old a few days ago. The plaintiff father really never did anything with this child. He'd work a lot, come home, he'd spend 10, 15 minutes with the child at night. That'd be about it. Then he would play video games. As far as the gun incident is concerned, it's very concerning. He actually shot himself at a CPL, getting a CPL license. He's got a 9mm. Gun went off, went through his hand. Luckily, didn't hit anybody else. It was in a confined area. I know accidents do happen. I'm a gun owner myself, but the pictures that I saw of AR-15 against the wall in the home that my client lived in with him, shotguns, rifles, out in the open is not tolerable, cannot be tolerated. Any type of parenting time he has, all weapons should be locked safely, secured in a safe. He also carries quite frequently. We don't want him carrying a weapon when he's got the child. So we absolutely, that's a mandated thing, Your Honor. But as far as the child, I mean, he's just hasn't bathed the child, didn't feed the child, didn't diaper the child, didn't ever go to the doctor with the child. All those things fell on my client. So going forward, we would ask that, I mean, he has some parenting time, and my client's never denied him parenting time, Your Honor. Either there's a sickness, I think there's a germ phobia over there. If the child's sick or sniffly nose, doesn't want to have the child. I mean, we offered this week for him to have the child a couple of times, and he was sick, so he couldn't do that either. So there's always some excuse there. But going forward, I would say that well, actually, his parenting time classes would be good. My client feels he doesn't really know how to care for an infant. I think there's opportunities in Battle Creek area with community fatherhood, various places where he could get some skills for parenting time when he has his parenting time. So going forward, we would say, custody remains with my client. Legal should remain with her as well. The child is on Medicaid. My client is not working because of the fact of the expensive daycare, which could be $200 a week. I mean, she is looking for work and she will ultimately go back to work, but at the present time with an infant, she's been home with him. So going forward, we would say that there is the policy that Calhoun County goes with. But my client would really like to has opened up her home that if he wanted to visit there for 3-4 hours, and then we could ramp up to something more, Your Honor, to, ultimately an overnight maybe with him, as long as all the safeguards are in place. No guns. He has some parenting time classes. And then we go forward, Your Honor.
Okay.
And then, I think a child support order ought to enter per the guidelines.
Mr. Vanderhorst, you pushed for parenting time classes. Is your client willing to take parenting time classes?
Yes.
Okay.
Yes, Your Honor.
Okay. Ms. Capture, response.
Your Honor, again, the incident with the gun has absolutely nothing to do with the minor child. All guns in the home are adequately secured. And my client has said that if that is a barrier, he's willing to remove the guns from the premises altogether, simply because he wants to have time with his child, which is the right of every single parent in this country. There is nothing in his history that would prevent him from having adequate time with his child. Half and half. That is exactly what he is entitled to. He has no criminal history. He has no mental history. He has absolutely no domestic violence. There is nothing suggesting that he shouldn't have 50-50 parenting time. At minimum, he should be awarded standard parenting time. He has adequate housing. The child can stay in the crib in his home. There is nothing suggesting that he would be required to take parenting classes. Certainly, he would be open to the idea, but for them to be court ordered is as if he is being punished for being a young parent, which so is defendant. Many parents in this country parent without parenting classes. There's no issues with sobriety. There is no issues with drugs. Nothing within the requests that defendant is stating is warranted in this matter. These are both able-bodied parents who have divided their parenting responsibilities, where plaintiff was the primary financial bringer and defendant was the primary caretaker. Now that defendant has decided to leave the house, she believes that she is fully entitled to the child and plaintiff is not. That's simply not how this works. Plaintiff should be able to have his 50% parenting time and take care of the child just as much as defendant should, and defendant should be required to have a job. That is what we are asking for, Your Honor. Again, we are fine with paying child support. My client is fine with removing the guns from the premises. But at minimum, there should be standard parenting time. But in all fairness, it should be 50-50.
Okay.
Thank you.
Anything else, Mr. Vanderhorst?
Well, Your Honor, I believe 50-50 is, not even close to what's in the best interest of this child. Defendant Mothers has really the established custodial environment since birth, even though they might have lived together 9 months. She's raised this child. Father's been absent at work, and even when he's home, he's absent. So I would say the ramped up, the parenting classes are fine for both parties if that's what the court wants to do. But I think we do some sort of ramped up where he has a few 3-4 hours a week or a couple times a week, whatever the court says, and then ultimately get into some overnights on the weekends when, quite frankly, plaintiff's ready.
Okay. Well, the court has read the pleadings in this matter as well as heard the oral argument in this case. Obviously, there is nothing in the record or as stated that would require parenting time classes by either parent in this particular matter. When the hospital sends a child home from the hospital after birth, they don't require that the parents take parenting time classes, nor do they give them, a outline or anything else. And I don't see anything that's been submitted or alleged in this matter which would require that. So the court just looks at that as just a red herring in this particular matter. Likewise, the issue of the gun, there was apparently an accident during the CPL class. The court doesn't infer anything from an accident happening. Obviously, you're taking the classes, and maybe something obviously didn't go right at that because you don't hear of it, but it doesn't infer that somebody had done anything wrong or mishandled. That simply was an accident. So the court will not take any action or restrictions as it relates to the gun in this matter as well. It does appear, based upon what's stated, is that the parties were together with the child till sometime in December, that they separated at that particular time. Up until that time, they both had equal access to the child, had equal involvement, although one parent, in this case, the plaintiff, the defendant may have done more. Court looks at the Bothasill case and states in that one that said that each party contributes differently to the raising of the child, but you cannot minimize one of the parents' I guess, involvement because they don't do anything or the same things as does the other parent. What the court's going to do based upon the young age of the child and based upon the fact that the parties were involved equally prior to the separation, a court is going to grant to the parties joint legal and joint physical custody. The court will set parenting time on a 2-2-3 schedule, and I assume that the child is with the defendant at this point, so she will commencing today will get her 2 days, and then thereafter the the plaintiff will get his, and then the 3 days thereafter. So put the start dates in that miscapture. The court will, in this matter, impute income to the defendant. There are a labor shortage in all the communities and in the state, and anyone could get a job at $15 per hour. The court will impute $15 per hour to the defendant and utilize the sum of $17 per hour, which was the stated income of the plaintiff in this matter. This capture, you can calculate that support as well. That will be the order of the court on an interim basis. Anything else, Ms. Capture?
I have nothing further. Thank you, Your Honor.
Mr. Vanderhorst.
No, Your Honor.
Okay. Ms. Capture, you can prepare that note the appearance of Ms. Thomas on behalf of the defendant. This matter is before the court on the defendant's motion to show cause for failure to comply with the judgment of divorce in this matter. Ms. Thomas.
Thank you, Your Honor. Your Honor, we are asking, we asked the court to do a show cause in this particular matter because the plaintiff has not shown any attempt or intent to pay Ms. Force pursuant to the judgment of divorce in this matter. He owes her $20,000 as her equity in the marital home. And although Mr. Force apparently has ability to do other things, our understanding is he's gone to Florida, he's gone to Tennessee, he's been to Hawaii, and if I'm not mistaken, he's currently in Mexico. And therefore, he's got money to do other things. He's not paying her. We're asking then for that he be held in contempt of court, obviously, that the defendant receive a money judgment against plaintiff in the amount of $20,000 plus attorney fees and costs in the amount of $770 plus any statutory judgment interest until the time that it's paid.
Okay, thank you. Mr. Force, what's your response?
So I have been in the process of trying to get an equity loan out on my house. I have been in communication with the bank. Due to the house being a manufactured home, there's been a process. They're requiring paperwork that I've been trying to get from the state of Michigan. I've sent an application in with a money order to get the proper documentation for the manufactured home for the affidavit of the fixture. I have yet to receive that, and I gotta try to find more information that I currently just don't have. It's just been a pain, the whole process of it. It's taken longer than anticipated. There's $23,000 equity in the house that I'm able to pull out. It's just a matter of getting the proper documentation from the state of Michigan to be able to give to the bank for them to approve the loan. I've already paid $500 for a house appraisal that is going to be now expired, that I'm also going to have to get the house reappraised. So that's going to be another probably $500 out of my pocket due to the just not proper documentation that I don't have.
Okay. Well, in this particular matter, as the parties are well aware, the judgment of divorce does provide that the plaintiff would pay the defendant the sum of $20,000 within 90 days of entry of the judgment. The judgment of divorce was entered on August 21st, 2023. And as a result, that again, that amount to be paid would have been paid in sometime in the late October. It is now February 20th, so sometime is expired or transpired since that time. Court will note that the plaintiff has stated he's attempted to do the refinance or to get the money, but notwithstanding that, he's not complied with the terms of the judgment. The court's not going to hold him in contempt at this particular point. The court will, however, grant to the defendant a money judgment in the amount of $20,000, together with a award of the cost and attorney fees of $770 as required and requested by Ms. Thomas to bring this matter before the court. Ms. Thomas, you can in fact submit that under a 7-day notice of entry in this matter, and that will be the order of the court at this time. Hopefully, Mr. Forrest, you can get this done, get her paid, get this over, and move on. So that is the
That's
hope.
always been the goal.
Okay, thank you. Court will end this matter at 9:36 a.m. You're free to go. Have a good day.
Thank you.
7 a.m.
Court will note the appearance of Ms. Storm on behalf of the plaintiff, Ms. Ives on behalf of defendant. This matter is before the court pursuant to the plaintiff's motion for temporary parenting time. Ms. Storm.
Thank you. Good morning, Your Honor. So we were last before this court on October 16th regarding the issue of temporary parenting time, at which point this court did grant our motion for the interim parenting time, specifically regarding after-school parenting time on Mondays, Wednesdays, and alternating Wednesdays that are not my client's typical parenting time. He would normally provide after-school childcare from after school from about 3:45, 4 o'clock-ish most days until about 6 o'clock p.m. The court did grant our motion. However, almost immediately after that hearing, we had trouble with compliance with said order. Mom began having more days off of work and having more early out days. And instead of allowing that time with my client or even having that time herself, the child would remain in the after-school program that is part of the issue with the clients until 6:30 at night. Further, mother has changed her job 2 times since the entry of that temporary order, or since our hearing on that temporary order. First, she was getting out earlier, and her pickup would then be about 4:30, allowing only about 20 to 30 minutes of parenting time after school for my client. Or now that she has gone back to her old job, she is getting days off that now align with the days that my client would have had. There have been multiple days where my client has been denied the parenting time. For example, in November, he would only be allowed that after-school parenting time on Mondays. It was not allowed on Tuesdays or Wednesdays. And in February of this year, he's already been withheld 4 days, February 5th and 6th, and 12th and 13th. There are additional issues regarding snow days and whether or not the child would be able to have those times with my client, or if he would be left with the child's great-grandmother who is elderly and has some health issues that are concerning. And so it just seems as though mom is bent on getting around our orders any way she can. I know we have a hearing coming up, but we just wanted enforcement of the temporary order so that my client can continue to have the after-school parenting time until 6 o'clock p.m. on the Monday, Tuesday, and alternating Wednesday. That is not his typical parenting time. His typical parenting time until we're able to get these issues resolved by the court. Thank you.
Okay, thank you. Ms. Ives, have read your answer, so you don't need to reiterate that. Any other response?
I don't, Your Honor, but I think ultimately if my client is able to be out of work in time to pick the child up from school, the school does not let the children out until 3:50 p.m. And most times the plaintiff will pick the child up to an hour early before school even gets out. And when my client is available and has the opportunity to either not work or be out of school or be out of work early, she has routinely and historically had that time on Mondays and Tuesdays. And we would ask the court that, the idea is that dad is kind of getting the first right of refusal. But this child is in school until 3:50, and if he's going to exercise parenting time, we'd ask that, you know, if my client's not out of work, that he have that time at 3:50 p.m. when the school child gets let out of school, and then until mom gets out of work. But, you know, like I said, Your Honor, the only reason why my client doesn't pick the child up at 3:50 is because the plaintiff has already picked the child up. There is an after-school program that the child really likes. It's called the 21st Century Program. My client enrolled the child for an after-school extra learning program that allows the child to have care up until 5:30. When my client is out of work early and the child wants to stay at school and do the learning and the creativity things that they do, she has been letting him do that. But that's just because the only way she's able to do that is because she's out of work early or gets there. And that's assuming that he hasn't picked the child already up before he got out of school. So it's a little bit of a quandary, Your Honor. We'd ask that the court at least order that the child be maintained in school until the school lets out. I mean, that's going to be one of the issues that the court's going to hear on March 14th, I believe, is where the child will go to school. Thank you, Your Honor.
Okay, thank you. Well, what the court did in this time when we entered that order back from the hearing on October 16th, the intent was that the plaintiff would be able to pick up the child when the defendant was working and couldn't pick up the child. It appears now from what's been stated that that is not now needed, or at least not needed every day. And as a result, the court will order that the plaintiff can pick up the child at 3:50 until she gets out of work. Not an hour early, 2 hours early, whenever he decides to, but whenever school is out until she gets out of work. And if she's not working on those particular days, or she gets out and is able to take the child, then she has the child from the time she gets out of work. Court will note if she's done and manipulated this in any way that's intentional, the court will consider that in the factor of the willingness of the parties to facilitate a relationship with the other party. But if it simply is a matter of her schedule, the court's not going to, again, hold that against her. But the court will address those matters at the trial set for March 14th. The court would note that, again, the child getting out of school, that's the regular school. It doesn't include the time in this after-school program, this 21st century program. You know, if we were to do that, the parent could load the kid up with any number of programs they want. And in fact, that would eliminate or obviate the other parent from having time. That's not the intention either. And likewise, with the reference to the snow days, if there are snow days and the kid's not in school, mom's working, then he would get that child until such time as she's out of work. So that would be the clarification and intention in this matter. Otherwise, the court will deny the motion other than as stated. I guess, Ms. Storm, it's your motion. I'll let you make those clarifications and submit that under a 7-day notice of entry.
I will, Your Honor. Thank you.
Okay. Thank you. Court will end this matter. You're free to go. Have a good day.
Thank you.